I call the member for Macarthur.
Thank you, Madam Deputy Speaker. I rise today to support the Personal Property Securities Registration Commencement Bill and the regime established by the Personal Property Security Act. The Personal Property Security Act establishes a national system for regulating personal property and security interests. This will repeal the fragmented and confusing system that currently exists. Central to this new system is a national online electronic register which is to contain registrations of personal property and security interests. Party can seek registration of their interests through a registration application either before or after they have entered into a security agreement or when the security interest has attached to the personal property. The reforms will also introduce uniform interest priority rules and interest enforcement mechanisms that will apply to all personal property and security interests across Australia. Naturally, a reform of this magnitude will have substantial impact upon commercial dealings in this country. Because of this, I would encourage the government to complement the rollout of these reforms with an education campaign that so businesses, especially small to medium-sized businesses, will be able to understand precisely how the reforms will impact upon them and their operations. I'm also concerned by the fact that the bill before the House today seeks to delay the commencement of these reforms and that no explanation has been offered as to why such an extension of time is appropriate. The existing system of Australian personal property securities law involves more than 70 Commonwealth, state and territory acts administered by 30 government agencies. This is problematic due to the following reasons. There are different registers for different kinds of data, property and reforms of securities. Because of this level of particularity, some forms of securities do not have the appropriate register and thus cannot be registered. There are different rules for registering different forms of securities. Some registers are electronic while others are paper-based. Different registers have different consequences for non-registration, and in some cases, a security interest must be registered in more than one jurisdiction for it to be fully effective in its provision priority protection for the creditor. There are substantial compliance costs involved in investigating the appropriate register. The different rules which apply for registration of different interests and registering an interest in numerous jurisdictions. The fact that these costs exist has deterred businesses away from registering their personal property and security interests under the existing voluntary registration system. This practice of not registering their interests exposes businesses to risks associated with personal property being used as security for subsequent borrowings. If this occurs, businesses as second-hand lenders would not be made aware of any other existing security interests in the property. Furthermore, even if an interest is registered, the second lender would be hard-pressed to find any other existing security interest in the property due to the lack of uniformity and organisation under the current system. This situation of uncertainty has substantial implications for businesses, including losing their interest in the property upon borrower becoming insolvent and the first lender claiming their superior interest during liquidation. The presence of these issues prompted by the Law Reform Commission to recommend the establishment of a single system that would uniformly regulate personal property security priorities in all Australian jurisdictions. In 2008, this recommendation was considered by the Council of Australian Governments, COAG, who supported the idea of a single online national system for the registration and regulation of personal property and securities in Australia. COAG advocated that a uniform national system would lead to significant cost savings for business through reduced compliance costs and greater choice and certainty for consumers and businesses who borrow money against secured personal property. The legal profession has echoed this sentiment by conveying that the establishment of a national law which is supported by a national electronic register will result in substantial efficiency gains, despite the fact that the reforms will introduce major changes to Australian commercial law. Madam Deputy Speaker, my coalition colleagues and I, particularly the member for Solomon, support the much-needed reform of Australia's personal property securities law that the Personal Property Securities Act offers. We agree with the attestations that the Law Reform Commission, COAG, and the legal profession of a need to simplify the regulation of personal property security interests in Australia. Madam Deputy Speaker, the Personal Property and Securities Act regime represents the best way of achieving this. This is because the Act condenses the regulation into a national regime, which includes a national electronic register for all security interests in personal property, as well as uniform national priority rules and enforcement provisions for personal property interests. However, I do maintain concerns on the level of education that has been provided to small to medium-sized businesses on the potential impact of these reforms. Madam Deputy Speaker, any potential injustices that could be caused by reforms to businesses will be due to the lack of an adequate education for those who are to be significantly affected by a new personal property security system. To avoid any potential injustices, these reforms should be complemented by a comprehensive PPS Act education campaign for these businesses and other relevant stakeholders during the commencement period of a new national system. Madam Deputy Speaker, I've received correspondence from those businesses in my electorate of Macarthur that engage in the hire purchase industry. They are concerned about the impact of these reforms on their business operations. Under the PPS Act regime, Madam Deputy Speaker, businesses engaged in the hire purchasing industry will face the unprecedented risk of losing ownership of their equipment. This is because the ownership on its own no longer guarantees the hire company's ability to retrieve their equipment if the customer becomes insolvent or inappropriately deals with the equipment in favour of a third party. In order to guarantee their interest of ownership, hire companies will have to register their interests for every item of equipment in accordance with the Act's regime. This represents a significant compliance cost for these companies as they change their inventory management and account systems so as to integrate the personal property security system into their business practices. However, once these companies adapt to the changes introduced by the regime, they will be able to reap the benefits of the PPS Act regime, and such benefits will include being able to check for prior interest when purchasing new equipment by checking Personal Property and Securities Electronic Register, being able to effectively secure their interests through perfection and registration in the event of a customer's insolvency, and a super priority given to purchase money security interests, the PMSI. This super priority applies only to goods that are inventory and allows hire companies to retain priority even if a subsequent interest holder in the inventory equipment perfects their interest before the hire company. Madam Deputy Speaker, this mechanism provides an important and necessary protection for hire purchase companies as it allows for a new regime to cater for specific needs of the hire purchase industry. Madam Deputy Speaker, the Personal Property Securities Registration Commencement Bill that is currently before the House seeks to amend the Principal Personal Property Securities Act to allow the Attorney-General to determine the commencement time for the regime to be other than that provided for in the Act. Essentially, Madam Deputy Speaker, it allows the Attorney-General, who's here in the room today, to extend the commencement time of the regime. On the 3rd of May this year, the Attorney-General announced that he anticipated that the National Register and the Personal Property Securities regime would be operational from October this year. However, this is not proven to be the case, and he is now seeking to pass a bill which allows him to postpone the commencement of the Act. Madam Deputy Speaker, no explanation has been offered by the Government as to why there is no need for such an extension of time. My coalition colleagues and I would encourage the Government to provide an explanation to a Senate committee so that the public can remain informed of the process of this substantial reform. This is especially important to the business community as they need to know when it will be appropriate for them to begin implementing their new policies and procedures so as they ensure effective compliance with the new system. Madam Deputy Speaker, businesses and industry associations have been trying their hardest during the past 2 years to seek advice so that they can educate themselves on the potential impacts of these reforms, how they will specifically affect their operations and how they can best ensure their compliance with the new system. By delaying the commencement of these reforms, the Government is leaving the business community in limbo yet again. They are being told that the reforms that have been racing for 2 years will be delayed, but not being told why. This leaves commerce in this country in a state of uncertainty, as the business community wonders whether there are going to be further changes made to the system. Madam Deputy Speaker, I would ultimately support the Personal Property Securities Registration Commencement Bill. However, for the reasons I've given, I would strongly encourage the Government to subject the bill and the reasons for it to the Senate Committee for their consideration. This is so that any issues associated with the implementation of the regime can be effectively resolved so as to provide the business community with the certainty that will allow them to effectively implement their Personal Property Securities Act compliance plans.